Anti-fencing law. First case. Dizon-Pamintuan vs. People. Facts. Teodoro Encarnacion, Undersecretary, DPWH testified that when he arrived at his residence, he immediately proceeded inside the house, leaving behind his driver and 2 housemaids outside to pick up his personal belongings from his case. It was at this point that 5 unidentified masked armed persons appeared from the grassy portion of the lot beside the house and poked their guns to his driver and 2 helpers and dragged them inside his house. They were made to lie face down on the floor, and thereafter, the robbers ransacked the house and took away jewelry and other personal properties, including cash. After the intruders left the house, he reported the matter immediately to the police. He was later told that some of the lost items were in Chinatown area as tipped by the informant the police, and an entrapment was made with their participation. He and his wife posed as a buyer, and were able to recognize items of the jewelry stolen, displayed at the stall being tended by Norma Dizon-Pamintuan. The trial court held that the prosecution was able to prove by evidence that the recovered items were part of the loot, and such recovered items belonged to the spouses Encarnacion, the herein private complainants. That the recovered items were found in the possession of the accused, and she was not able to rebut the presumption, though the evidence for the defense alleged that the stall is owned by one Fredo. The CA affirmed the decision of the trial court, but set aside the penalty imposed. Issue: whether or not the accused knew or should have known that the items recovered from her were the proceeds of the crime of robbery or theft. Held. Fencing, as defined in section of PD 1612, anti-fencing law, is the act of any person who, with intent to gain for himself or for another, shall buy, receive, possess, keep, acquire, conceal, sell or dispose of, or shall buy and sell, or in any manner deal in any article, item, object, or anything of value which he knows, or should be known to him, to have been derived from the proceeds of the crime of robbery or theft. The accessory in the crimes of robbery and theft could be prosecuted as such under the revised penal code or under PD 1612. However, in the latter case, he ceases to be a mere accessory, but becomes a principal in the crime of fencing. The state may thus choose to prosecute him either under the revised penal code or PD 1612, although the preference for the latter would seem inevitable considering that fencing is a malum prohibitum, and PD 1612 creates a presumption of fencing and prescribes a higher penalty based on the value of the property. The elements of the crime of fencing are: A. A crime of robbery or theft has been committed. B. The accused, who is not a principal or accomplice in the commission of the crime of robbery or theft, buys, receives, possesses, keeps AC2 wires, conceals, sells or disposes, or buys and sells, or in any manner deals in any article, item, object, or anything of value, which has been derived from the proceeds of the said crime. The accused knows or should have known that the said article, item, object, or anything of value has been derived from the proceeds of the crime of robbery or theft, and there is, on the part of the accused, intent to gain for himself or for another. In the instant case, there is no doubt that the first, second, and fourth elements were duly established. Robbery was committed on February 12, 1988 in the house of the private complainants, who afterwards reported the incident to the authorities and submitted a list of the lost items and sketches of the jewelry that were later displayed for sale at a stall tended to by the petitioner in Florentino Torres Street, Sta Cruz, Manila. The public display of the articles for sale clearly manifested an intent to gain on the part of the petitioner. Second case. Ong versus People. Facts. Francisco Azajar bought 44 Firestone tires from Filtred Tire and Rubber Corporation for P223, 401.81. This acquisition was evidenced by a sales invoice and an inventory list acknowledging receipt of the tires, described by their serial numbers. He marked each tire with a piece of chalk before storing it inside his warehouse. On January 1995, he sold 6 tires. However, on February, the remaining 38 tires were stolen from the warehouse. The gate forcibly opened. He reported the robbery to the Southern Police District at Fort Bonifacio. Hoping to locate the stolen tires, Azajar canvassed from numerous business establishments until he entered Jones Marketing, a store selling tires, owned by Jamie Ong. There he found a tire, which was marked and matched one of the serial numbers of the stolen tires. A buy-bust operation was conducted. 13 of the 38 tires were recovered. Ong was convicted of the crime of the anti-fencing law, PD 1612. He denied that he had knowledge that the tires were stolen, having bought them from Raymond Go of Goldwing. Issue: whether the elements of the anti-fencing law are present in the case. Ruling: yes. All the elements of anti-fencing are present in the case. First, Azajar was able to prove that ownership of the tires through the sales invoice and inventory list, and the happening of the robbery through their Sinamping Salese. Second, the facts established that Ong was in possession of the tires. The serial numbers of the recovered tires matched those of the serial numbers of the stolen tires. Ong also admitted that he bought the tires from Goldwing. Third, the words "should know" denote the fact that a person of reasonable prudence and intelligence would ascertain the fact in performance of his duty to another or would govern his conduct upon assumption that such fact exists. Ong's experience of 24 years from the business should have given him doubt as to the legitimate ownership of the tires, considering that it was his first time to transact with Go, and the manner it was sold is as if Go was just peddling the 13 tires in the streets. Moreover, Ong knew the requirement of the law in selling second-hand tires. He has practiced the procedure of obtaining clearances from the police station for some used tires he wanted to resell, but, in this particular transaction, he was remiss in his duty as a diligent businessman who should have exercised prudence. Finally, there was evident intent to gain for himself, considering that during the buy-bust operation, Ong was actually caught selling the stolen tires in his store. Fencing is malum prohibitum, and Presidential Decree 1612 creates a prima facie presumption of fencing from evidence of possession by the accused of any good, article, item, object, or anything of value, which has been the subject of robbery or theft, and prescribes a higher penalty based on the value of the property.